Hello, we're coming to you live from Houston, Texas. My name is Emily Newman. I'm a partner with Reddy & Newman PC. We handle complex immigration and try to make it simple for you. I'm also here today with one of our senior attorneys, Rebecca Chen.
Hi.
So Rebecca handles a lot of the tough cases that we're dealing with right now, so she should be able to answer lots of your questions.
Hopefully.
Coming up. So I think probably the big news today is the RFE memo.
Yeah.
Well, one of the big news is the memo about not issuing an RFE and going straight to denial took effect from today. So any application that was received today going forward is going to be subject to this memo.
Mm-hmm.
Now, do you think the memo is really going to be a big issue for most employment-based petitions that are filed by attorneys?
We don't think so right now. It does sound startling when USCIS issues a memo stating that they can straight out deny an application without issuing a request for evidence or notice of intent to deny. So we understand why a lot of people may be panicked. However, we did participate in a call last Thursday. The USCIS Ombudsman's Office held a public engagement call where they discussed specifically this memo, the RFE memo going into effect today. And it seemed to confirm kind of what we thought that the memo would be in effect, that they did emphasize repeatedly on that call that it was not meant to punish innocent mistakes made in applications. If there was a page missing from one document, it didn't mean that the application would be straight out denied. They were pretty vague, as they usually are on these public engagement calls. They didn't give too many specifics of what exactly they were looking for, but they did seem to emphasize that the point of the memo was not to punish innocent mistakes. The example that one of the representatives did give for a situation where there would be a denial without an RFE, for example, I think he mentioned there are some waiver applications that you can apply for with USCIS where if you're in removal proceedings, for example, and you have a U.S. citizen spouse, parent, or child that you have a qualifying relationship with who you can show will experience extreme hardship if you are removed from the U.S. If you apply for that waiver, but the relative that you're claiming will experience extreme hardship is a grandparent or a cousin or a situation like that where the application is clearly not approvable, that's the type of situation they are looking to deny without an RFE in order to, in their words, to cut down on processing delays or delays caused by excessive processing of placeholder or frivolous applications. So that's really what USCIS is aiming to cut down on, it sounds like, with this memo. I guess it will remain to be seen as we go forward.
All right. So they did post some new checklists on their website today for some of the application types. So for the typical work visas, if you go to the I-129 form section, there's now a new little spot where you can see the checklist of what they consider to be required initial evidence. Is there anything unusual, anything that we weren't already expecting in that checklist?
Not really. So this checklist was literally posted hours ago today. It's called a checklist of required initial evidence for Form I-129, and it's broken down by some pretty frequently applied for non-immigrant visa classifications that use the I-129 form. For the H-1B, which we know a lot of our viewers are applies to a lot of our viewers, it's pretty much what we expected. The items mentioned in the checklist are still pretty vague, no specifics, but for example, they list evidence the beneficiary maintains status if seeking a change of status or extension of stay. So basically evidence of maintenance of status, evidence showing that the employment qualifies as a specialty occupation, evidence showing the beneficiary is qualified to perform the specialty occupation, copy of any required license or official permission if the occupation requires a license, and a copy of any written contract between the employer and the beneficiary. I would say maybe this is one of the only things that maybe not all applications for example, an extension may have included as a matter of routine in the past, but that might be something people will want to start including in all the applications, a copy of an offer letter or employment contract between the petitioner and beneficiary. And finally, an itinerary showing the date and place of assignment if the work location includes more than one work location.
All right, we'll go to a couple questions here. So Srini is asking for any updates on the H-4 EAD. Right before we started, I went and checked the OMB website to see if there's been any proposed regulation given to them for review yet, and still, as of today, nothing.
Yeah.
So, nothing's going to happen with the H-4 EAD until first we have a proposed regulation that first, before you even can get that, has to go to OMB. Mm-hmm. They usually review for at least 30 days before it can actually be published. Once it's published, we're looking at 60-day comment period and then months of reviewing comments before they come up with a final rule. Mm-hmm. Final rule has to go back to OMB for at least a 30-day review.
Yeah.
And then a final rule is published with generally a 60-day advance notice. So nothing's going to be happening anytime soon. There's still no progress on getting the regulation to OMB.
Right. So people should still be applying for the H-4 EAD right now if they're still eligible. We still are. Even for people who have never had the H-4 EAD before, we're still filing the I-765s this month up until we hear anything official. It's still available.
So we're getting a couple of questions about people that have pending H-1Bs in the lottery. Maybe they got a request for evidence and responded to it and haven't heard anything yet. Yeah. For these people, some might actually be eligible for H-4. So they're asking, can I file a change of status to H-4? Will that impact my pending H-1B? How does that work if someone wants to file an H-4 as kind of a backup plan?
So for someone whose application was selected in the lottery in April.
And maybe they're on F1 right now,
right.
Cap gap, and their spouse is on H-1B.
Yeah. A lot of that will depend on when how their current F1 status stands. If they're on OPT, for example, when does the OPT expire? If they are still in status or on OPT, they could file a change of status application to H-4. However, it's likely that it may not get adjudicated until the H-1B gets processed, since it was filed earlier. Also, I-539 applications for a change of status from F1 to H-4 are taking several months. It's not going to be necessarily faster than the H-1B right now. It's very likely if you file the I-539 right now, it will still be pending in February at the time when hopefully premium processing will be available again for the H-1B.
One question on I-539. So I think earlier this week or maybe last week there was a notice about them transferring I-539s from the Vermont Service Center to the California Service Center. Mm-hmm. Do you remember which applications they're transferring, and is that a good thing or a bad thing for processing times?
I don't remember which ones they mentioned were being transferred, but it's usually a good thing, I think, for processing when they are transferring applications to different service centers. It's usually because they recognize there's an enormous backlog and are transferring them to service centers that will be able to process them faster than wherever they have been pending.
Okay, we're seeing this a lot right now as we're getting closer to October 1st. Say somebody has an H-1B approved in the CAP, getting ready to start October 1st, and they just got laid off. What are their options? Are we seeing difficulties in filing a transfer on October 1st? Anything they need to be worried about?
Definitely don't file a transfer prior to October 1st. We know that is definitely not an option. After October 1st, transfers can be filed for applications that were initially selected in the lottery. It will depend a lot on whether the petitioner of the application that was filed in the lottery withdraws it before October 1st. Hopefully, if they want to kind of help the beneficiary at least transition to a new job, they will allow the H-1B maybe to stay approved beyond October 1st until they can file a transfer to a new company and then withdraw it. Because, let's see, if an H-1B application that was selected in the lottery is withdrawn prior to October 1st, Emily, is that beneficiary still considered counted in the cap?
Right, yeah, that's a big problem. They'll basically become uncounted at that point. And so, yeah, it gives you kind of the best of both worlds. If they will allow the H-1 at least to take effect on October 1st, then you can take advantage of the 60-day grace period for H-1 holders because of the job loss, and you basically have 60 days to get that transfer filed to another company rather than having to wait until next April going through the lottery again.
Right. I've been doing the conference call for our office this week, and a question I've been receiving a lot is for individuals who did get their H-1B application selected in the lottery. It's still pending, but they are in the cap gap right now. Their OPT expired sometime over the summer. So what happens to them now in light of the premium processing suspension?
Yeah, it's a really tough situation. Unfortunately, employment authorization ends on September 30th, no matter what. So from October 1st, you will then be in the 60-day grace period of your F1 time. So if the H-1B is approved anytime during those 60 days with a change of status, then you can start working as soon as that's approved. If the H-1B is pending beyond those 60 days, so at this point beyond November 29th or 30th. Again, if you get an approval, everything's fine. So you are in a period of authorized stay. Once your 60-day grace period ends, you move into a period of authorized stay, which is not quite the same as status, but it does allow you to stay and wait for the approval. So once it's approved, then your H-1B kicks in and everything's good. The risk is if your H-1B gets denied after your 60-day grace period has ended, there's not a way to go back to F1 status. There's not a way to file any other kind of change of status because the denial puts you immediately out of status and you immediately start accruing unlawful presence from the day after the denial. So sometimes it might be a good idea to try to maintain your F1 status beyond the cap gap by enrolling in a new program. For that, you need to get the new I-20 from a school. I would probably stay away from these schools that are giving the day one CPT. I think they're highly scrutinized right now and on USCIS's radar and the ICE radar. But that is one option to continue to maintain your F1 status. But you have to get that I-20 before the end of your 60-day grace period. If you wait and try to get it after, you're no longer in F1 status, so you have no way to continue. You could also file the change of status to H4 during that time as a backup, like we talked about earlier. Let's see. So with all these H-1B RFEs going on right now, what are you seeing as far as timeline after a company's responded? How long is it taking to get the approval?
Yeah, for the majority of the CAP subject applications where we've responded to an RFE this summer, we have heard nothing. There are a couple that we have gotten approvals on, but the majority of the applications that were selected in the lottery that have had an RFE and we've responded to the RFE this summer, they are still pending. Even beyond, on the first page of the RFE, it lists like a 60-day time frame where you can maybe expect a decision after submitting the response. A lot of them have gone past that 60-day time frame, and unfortunately that's not unusual for regular processing cases. I think last year in the CAP subject applications that remained in regular processing that were never upgraded to premium, some of them remained pending for a year, 14 months sometimes. So unfortunately, USCIS can sort of just sit on those RFE responses for an indefinite amount of time. We're hoping that they won't, and that there will be a decision, in the next few months, toward the end of this year. But yeah, we just can't be sure.
So with no premium processing for H-1B transfers, is now a good time to be looking to change employers? Are there situations where it might be a little safer to file a transfer in regular processing right now?
Yeah, transfers are also highly impacted by the premium processing suspension. I would say besides the cap gap, people with the pending H-1B, they're the other main classification of H-1Bs that are affected by the premium processing suspension. The reason for that is when you file a transfer application to a new company, the beneficiary can start work with Company B based on the receipt notice of the transfer application. But, and although that may have been something that a lot of people did in the past, join the new company based on the receipt notice, that is a much more risky prospect now with the premium processing suspension. That's because without premium processing, that transfer application can be pending for 6 to 8 months at least, I would say. And whether you are eventually considered to be in status during those 6 to 8 months that you're working for Company B will depend on the eventual approval of the transfer application. If the transfer application is eventually denied and your previous company, Company A, has already withdrawn their H-1B for you, which is very likely, you are immediately out of status without really a good way to fix it. Yeah, so transferring employers right now is very risky. I would say the only situation where you should consider it is if you are okay and able to wait for the approval of the transfer before joining the new company. But without premium processing, that could also take several months.
Have you seen any updates on the NTA memo? Is that going to be implemented anytime soon?
Well, we haven't heard any recent updates. The memo was issued at the end of June, became public knowledge kind of in early July, and in the memo, the service centers were kind of given about a 30-day time frame to sort of work out how they would implement the memo. So 30 days after that, the service center or USCIS basically sent an update saying that they were still working on it, and we haven't heard anything since, as far as I know. It could be implemented at any time, but I don't know. What do you think they are working on that's taking so long?
Yeah, I think that they've got to come up with their processes for how they're going to issue the NTAs, who's going to issue them.
Yeah.
Because the USCIS really is not in the habit of issuing NTAs.
Right.
And looking at how many cases are getting denied these days, how many are happening after an I-94 expires, I think there's going to be a lot that they have to be prepared to issue. And I think they need to provide some sort of guidance on how long they're going to allow the person to pack up their things and make plans to leave.
Yeah.
Especially in high-skilled immigration. I mean, the people have their families here, they've bought a house, they have cars, pets. And you can't expect them to get a denial today and leave tomorrow. They've got to be given some time. Their kids are in school, It's not an easy thing to just pack up and leave. So hopefully they will take that into consideration and give enough time for people to leave before an NTA starts being issued. I've seen a couple of questions about PhDs. Do you think getting a PhD is a good option for potential EB-1 green card? Is just getting a PhD going to be enough to get someone into EB-1?
Not just having a PhD. There are a few categories of EB-1 eligibility. One of them is for aliens of extraordinary ability. That one has a list of, I believe, 10 or so criteria that the alien needs to demonstrate in order to be deemed extraordinary according to the regulations. A PhD degree could be one of those, but on its own, it's usually not enough. What are some of the other criteria?
Yeah, so you really have to be contributing to the scientific community or the industry. beyond just getting a PhD. So they're going to be looking at what you've published in respected journals, what's been published about you and your work in the media. Are you a member of any kind of organization that requires, advanced knowledge or a high level of contribution to be able to get into that group? So those are kind of some of the main things in addition to just getting the PhD, what kind of awards you've received. And they don't look at just awards you got while you were in school. They want to see awards outside of school. Maybe you filed a patent or something like that. So just getting the PhD gets you started in moving towards EB1 level, but you've got to do a lot more than just get a PhD.
Right.
BJ has a question about the RFE rule, the 9/11 rule, as people are calling it. So if someone has an application that's already filed before 9/11, does the RFE memo apply to it?
Technically not. So the memo on RFEs and NOIDs is pretty clear that it affects petitions received on or after September 11th. So anything that was received by USCIS prior to the 11th will theoretically still be subject to the prior procedures in the Service Center, which is to send an RFE as a matter of course before denying anything.
All right, here. Have we seen any actions, any updates related to the unlawful presence memo for F1 students yet?
Not really. We just know that it went into effect August 9th. I would say probably the most serious effects of the memo won't really be apparent until 180 days after, when the 3-year bar starts to take effect, or even after February, actually, when people start traveling and perhaps the 3-year bar is applied by the consulate, or people learn about the bar at the consulate. Yeah, it's still very serious, I would say, for a lot of F1 students. It seems like a lot of people that I've talked to on the conference calls or in consultations still aren't maybe aware of the exact consequences, because the memo itself is very, unless you are well versed in the terms of out of status and unlawful presence, it all seems kind of the same to you, and until you see actual effects, people may not be taking it as seriously, but it does seem designed sort of to affect F1 students next year who are currently doing maybe first day CPT programs or second master's degree programs and getting additional practical training. The effects of that under the August 9th memo will mostly take effect next year in the H-1B applications or any other applications that are filed next year. So we continue to caution people against first day CPT or first year CPT programs or second master's degrees. Yeah, it's, even though schools are issuing it right now and it seems easy to get right now, an easy form of work authorization, it can have much more serious consequences next year as a result of this memo.
One question that came up is with an H4 EAD renewal. So say they filed the renewal of the EAD card and their current card is about to expire and they don't get the new card yet. Can they keep working based on the pending renewal application?
There are a couple of types of EADs where you can keep working based on the pending I-765, but I don't believe the H4 EAD is one of them.
Yeah, and so I think this question goes on to ask, if I stop working, can I just go on an unpaid leave of absence, or do I have to actually stop being an employee? And it's a bit of a gray area, and I think it really depends a lot on the employer and what their immigration attorney is guiding them. It can create a problem for the company as far as their I-9 compliance. If they are, even if you're on a leave of absence, if they're showing that this person is still considered an employee, but on an unpaid leave, they're technically don't have employment authorization, so how can they be an employee? So I do think that is something that companies should be careful of, and probably it would be better to terminate the employment relationship and then rehire once you get the new EAD, rather than trying this unpaid leave of absence. I would say the same thing for CapGap, for those that have to stop working on October 1st. An unpaid leave of absence probably is not the best choice there, but it really, the company should be discussing that with their immigration attorney.
Yeah. A question I've also gotten in recent days is, so our office was very busy this past week filing applications in premium processing to reach the service center before September 11th. So people have been checking the tracking information, making sure the package was delivered before the 11th. If it was, does that guarantee that the application will be premium processed?
No. There was a little bit of what I would call fine print in the premium suspension announcement that kind of gave USCIS, Vermont, and California Service Center some wiggle room to where even if you got it in before September 11th, they could choose to accept the premium processing case, cash the check for the filing fee, and then if they can't get it done in 15 days, refund the filing fee and convert it to regular processing.
Yeah.
We saw that happen particularly with Nebraska Service Center last year when there was a suspension. We had a number of cases that were filed before the deadline but were ultimately converted to regular processing. So that was a little unfortunate. So yeah, there's definitely no guarantees that it will be in premium. Also on that, I've been seeing a little bit of delay in getting the email notifications. So there's a couple that we know were received on Monday, but we still haven't gotten the email notification from the premium processing unit. So something to keep an eye on, but I wouldn't be too concerned about it because I'm assuming they received a ton of applications yesterday and are just trying to get through them all to get them into the system.
Yeah, I think last year what we saw was, there was just an influx of premium processing cases at the end of March in 2017 because everybody knew it was about to be suspended for all H-1B applications, and the service centers just couldn't premium process all the applications that they received in that 1 week span. From what I remember, however, even for cases where the premium processing fee was refunded and the service center said that we can't process this in 15 days, here's the $12.25 back, this is now in regular processing, I remember getting some of those applications back or decisions on those much sooner than they usually would have been in regular processing, like within 1 to 2 months rather than 6 to 8 months. So hopefully if there are applications that reached the service centers before the 11th and the $12.25 check gets refunded, hopefully the service center will still make an effort to process it faster.
All right, I've seen a couple of questions related to the 240-day rule. Can you kind of give us a quick overview of what is the 240-day rule? What types of cases does it apply to now that there's no premium processing?
Yeah. So the 240-day rule applies to extension applications where the extension application was filed prior to the I-94 expiration date, so it was filed timely, and it refers primarily to work authorization. So for any type of non-immigrant visa application, if the extension or a change of status application is filed prior to the I-94 end date, the beneficiary is considered in a period of authorized stay after the I-94 end date during the pendency of that application that was timely filed. The 240-day rule gives work authorization for up to 240 days beyond the I-94 end date for those applications that remain pending beyond the I-94 end date. It does not apply to transfer applications or amendment or other types of applications, only to extensions. So theoretically, for transfer applications, that work authorization is indefinite, possibly.
Yeah, as long as the transfer is pending, you're allowed to keep working for that company, as long as it's a timely filed transfer before the I-94 expires and while you're still maintaining status. But with these long processing times, with extensions with the same employer, definitely keep an eye out on the 240 days. When does the 240-day start counting? Is it from the time of the extension being filed or the time of the I-94 being expired?
I believe it's from the time the I-94 is expired. So it's about 8 months of work authorization beyond that. If the application remains pending beyond the 240 days, the applicant could remain in the U.S. in a period of authorized stay, but would not be able to work. So our office has dealt with that situation a couple of times. What have we done in the past to continue that beneficiary's work authorization?
Yeah, typically before we get to the 240-day mark, I mean, when we had premium processing, we would upgrade it to premium to make sure we got the answer in time. But now that that's not an option, in order to extend the work authorization, we would basically file another extension. And then from the time of filing that, it would start another period of 240 days in order to get the extension approved. So if someone has filed an extension and now they have an RFE on it and they're getting a little worried, is now a good time to file a transfer? Does it matter if the I-94 is still valid or if it's expired?
It makes a huge difference whether the I-94 is still valid or if it's expired. Before the I-94 expires, there are a lot of options. Even if the extension gets denied, the same company can refile the extension and there's no problem. Another company can file the transfer and there's no problem. The other company can file the transfer while the extension is pending prior to the I-94 without a problem, and you have a couple of options going with the extension or with the transfer if it's eventually approved. Everything changes if it's after the I-94 end date, because at that point, after the I-94 is expired, the pending extension becomes a bridge application, and a transfer could be filed at that time, but it's dependent on the eventual approval of the pending extension. And if that extension is shaky, if it looks like it's going to get denied, or if it does get denied and you have already transferred to the new company, that is a very dangerous position to be in, because you're out of status and possibly unable to go back to the old company. Or if the extension has been denied, you can't even go back to the old company. And before September 11th, there would have been some options, not great options, but there were options to at least fix a situation like that, such as consular processing. You could have the application filed in consular processing, premium process it, and it would just require an additional trip outside the U.S. and going through the visa stamping process before you could come back in and get back in H-1B status. That is not even really an option anymore, because consular processing applications are among the applications subject to the premium processing suspension. So even if in that situation Company B or Company A was willing to refile the application for you right away, you won't get the approval until the end of February at the earliest, if premium processing comes back in February and you can upgrade it to premium processing. But in regular processing, that consular processing application will be pending for several months.
Are you seeing any new issues being brought up in RFEs this year compared to previous years, or is it just the same old but just more common that we're getting RFEs now?
Yeah, I would say the latter. There haven't been any huge surprises in the types of RFEs that we've been seeing, especially not the types that we saw last year, where level 1 was like a brand new issue that we saw in RFEs last summer. There hasn't been any surprises like that this year, I would say, but definitely we're still getting a lot of RFEs on the same issues, such as specialty occupation, availability of specialty occupation work, some on beneficiary qualifications. We are seeing that more and more when the beneficiary's education is not an exact match to the H-1B specialty occupation. We're getting questioned on that a lot. But for the most part, no particular surprises, I would say.
What are your thoughts on L1s? Are they as easy as they were a year ago? Any more difficulty getting them now than before?
Yes, I would definitely say L1s have gotten more difficult in the past year. A lot of that seems to be as a direct result of the Buy American, Hire American executive order that was issued in 2017. We see a lot of the kind of Buy American, Hire American mindset in the RFEs that we get for L1s. It seems to be affecting even L1 visa interviews at the consulates abroad. Apparently officers are sometimes asking L1 applicants, why can't an American worker be hired to do this job? For L1B applications that are for specialized knowledge, intra-company transferees, the standard of specialized knowledge seems to keep getting pushed higher and higher, where you almost need to prove that there's no one else on earth besides this person who can perform this job, when the standard is not that high. For L1A petitions for managers and executives, we're having to include documents that have never been asked for before. For just one small example is a letter from the foreign qualifying entity confirming the beneficiary's experience abroad. Used to be sufficient as proof of their employment. Now we're having to provide pay statements for all their years and months of service in the foreign entity. We're having to provide complete letters on the letterhead of the foreign entity, copies of performance reviews, pay stubs, job descriptions for each subordinate that an L1A manager has under them, reporting to them. Just the amount of evidence and the standard for an L1A or L1B has increased significantly.
Yeah, I think particularly for the L1As, you know, if an employer calls someone a manager or calls someone an executive or something like that, and it's a typical executive or manager type job title, they assume that's enough to prove that it should be qualifying as a manager or executive, but it's not enough anymore. You've really got to describe the daily job duties, break it down, what's the percentage of time spent on each duty.
Right.
I think they're really questioning, is this person spending the majority of their time working as a manager or executive, or are they actually doing other things that are maybe more product related, or doing the work themselves rather than managing the work. So that's something that employers really need to get in their heads, is it's not enough to just say this person is a manager. You've got to prove that they're actually a manager. Are you seeing any changes in how I-140s are being processed these days?
Not too much on my end as far as I-140s. I know that some of the I-140s in our office have been getting RFEs apparently asking about maintenance of status, asking for pay statements and W-2s to prove the beneficiary's maintenance of non-immigrant status. I don't know how common that is or if it's a trend necessarily, but for the most part I would say I-140s that I've seen this year have been pretty standard.
Yeah, and I think labor certification is probably the same. Not much has changed in terms of processing and how they're reviewing the applications. Processing times are relatively good right now. What about 485s? Now that we have the interview, you know, you've been to a couple of interviews in the last week. Can you kind of share some of your experiences from those? Yeah,
so the employment-based I-485 interviews are a relatively new phenomenon. They were implemented last October. So previously, employment-based I-485 applications, it was very rare for them to have to go into the local USCIS office for an interview. That became mandatory last year, starting in October. So we've been kind of seeing how USCIS has been handling these employment-based interviews since last year. I would say most likely the majority of the officers conducting the employment-based interviews don't have that much experience in employment-based immigration. Most likely they've been kind of transferred over from the family-based immigration side, where interviews are much more common, or naturalization interviews possibly, where it's always mandatory. So far, for our clients at least, we haven't seen too much inquiry in the actual interview into details of the I-140 or the employment history. There are usually some kind of perfunctory questions confirming who's your employer, what's your job, maybe what industry is the company in, how long have you been working there. But we haven't really seen the officers digging around too much into the details of the I-140. Having said that, we have heard reports from AILA, the American Immigration Lawyers Association, that kind of nationwide it does seem to be on the increase, that there are some officers who maybe don't fully grasp I-140s but are asking more questions about it, and sometimes incorrectly denying I-485 applications based on their incorrect understanding, especially I would say in porting situations. If you have moved to a new employer under AC 21, which you are allowed to do after 180 days, that your I-485 application has been pending. The I-485 application can still be approved, but we have heard officers denying some of those applications, mostly because they don't understand AC 21 portability. So there have been kind of headaches as a result of that. I think in those cases motions to reopen have been issued. But another thing that purportedly was the reason why employment-based interviews became mandatory was in order to ensure that the family relationships of any dependents of the principal applicant were genuine. So that was one of the stated intentions. So we have not only does the I-140 beneficiary have to go in for the interview, but their whole family, anyone else who's applying with them for the I-485. So I was with a family of 5 a couple of weeks ago. All the kids had to miss school and go into the interview, and the questions they were asked were very basic, but the officer also asked for all their birth certificates. I think they just want to see the family and make sure that it's a legitimate family relationship, apparently. But so people going in for the interview should be prepared to provide birth certificates for all the children, possibly to provide proof of the family relationship that you would normally see in an I-130 application. It's a good idea to have those documents with you just in case the officer asks.
All right, we'll take one last question here from Amit. He's in a situation where he has a valid visa stamp, has a valid approval notice. Now there's an amendment pending and he needs to travel. Is now a good time to travel? Is there anything he can do with no premium processing?
Let's see. So he has a valid visa stamp and a valid approval notice, and it's just an amendment only that's pending.
Yep.
I would say he should be able to travel. If it's an amendment only, that's not requesting an extension of status, and he doesn't need to, well, it depends, I suppose, on the reason why the amendment was filed, if it was a change of work location. But if he has a valid visa stamp, he should be able to travel, I would say.
Yeah, I think that there's some risk in entering based on the pending amendment if it's related to third-party placement. That can be risky. And also, even though there's some guidance out there from USCIS from probably 30 years ago that talks about entering while you have something pending, it can create problems, because you have to remember that when you filed your amendment and you have your approval, your previous approval, they have an I-94 on them, a specific number. When you travel and come back in, you're going to be given a new number, and then your amendment's going to be approved after that, hopefully, with the old number. So it creates a mismatch, and that can really mess things up in the system they use to verify driver's licenses for renewals. can mess things up with Social Security. So you might have to travel again to come back and get one more I-94 that's kind of a new number to clear that up. So it does create some headaches. It can definitely be a risk. So I would certainly recommend you speak with your attorney before making any travel plans to understand what the risks are and whether it's worth it to travel right now. All right, well, I think that's about it for today. If we didn't get to your question or you want more specific advice on your specific situation, you can always set up a consultation with any of the attorneys in our office by going to rnlawgroup.com. Please continue to follow us on Facebook. You can always find me on Twitter at Immigration Girl or at Twitter at rnlawgroup as well. And you can check out my blog, immigrationgirl.com, where I post all the updates and answer a lot of questions there. So thanks for joining us today.
Thank you.